ladies and gentlemen, she is back. So we're in verdict watch. We're literally in verdict watch. The jury's out to lunch right now, but I know a lot of people have been locked in on this case, and we've been following this case for some time now. Uh, I just want to discuss some of the things that we now know what is happening in this case. I'm literally getting messages about the case right now. I want to make sure no verdict is in yet, so we're going to be toggling back and forth, making sure our colleagues in New York are on top of this as well. What do you think about what you've seen in this case thus far, and do you think the state has reached their burden to prove Mr. Majors is guilty of the crimes he's trying to
Listen, I don't know why some prosecutors take cases.
Did I lose you?
Yeah, someone was calling. I don't know why prosecutors take cases that have so many issues that, to me, raises doubt.
Okay.
And the reason why I say that is because there is an art to prosecution, because you have.
Okay, she's leaving me.
Let me send this message.
Ladies and gentlemen, this is real time.
If a client calls you, so there's an art to prosecution because there's a level of power that goes into it. And a great advocate, aka litigator, aka prosecutor, will first comb through the issues of the case before it even reaches the level of having to be set for a trial. That shows that a person is over prepared to proceed on a matter that they feel they are confident and can prove beyond a reasonable doubt. Now, you have to marry your issues. You have to. There is no way to get around it. And if you go in and you try not to, and you try to disclose this from the jury will come back in and spin a block on you. And I like to say spin a block because they will, if you're not truthful. And the truth starts in the preparation of the case, even before it's set for a trial setting. And in this matter, I think that they did not do their due diligence to really hone in on beyond a reasonable doubt.
Okay.
And if you don't do that, you're going to get the public's opinion about everything that we have seen that has come out. Yes, the audio that he's asking her to act like Coretta and and Michelle Obama.
Michelle Obama and Coretta Scott King.
And was that, a great representation? No, but he's there in the privacy of their home or wherever they are having an argument, and unfortunately he didn't choose.
And she's recording?
She's recording. So of course he didn't choose right if you got to ask a white woman to act like black women. He should have known that from the jump.
Okay. So, before we get into that, because that's obviously an interesting piece of the case, let's look at the evidence. Let's look at, for example, today the jurors sent out two questions. One of the questions was in relation to charge number 4, which is harassment in the second degree. We're going to be joined by a former New York City Manhattan criminal prosecutor as well in a few minutes, and she knows how they work in New York City. She was one of the former Manhattan prosecutors.
Mm-hmm.
But they asked for the readback on the judge's instruction on harassment in the second degree, as well as they wanted to see the video of Jonathan Majors putting his girlfriend back in the car. Now, what would you deduct from those two questions if you can gauge, what is happening in that jury room?
If they're asking questions like that, to me, that says that the prosecution didn't do their job. Because when harassment, there are elements to prove through that this person has committed this crime beyond a reasonable doubt. And you as the state, it have a responsibility, and the burden is on you, and it never leaves your table, that you have to take them on the journey so that they do not have to come back with questions when they're in the back. And if a jury comes back with questions, this has happened to me, that means that I didn't do something right. I didn't do something in my case to convince them beyond a reasonable doubt that these elements have been met.
Now, this attorney, looks like she's an attorney at ESQ. She states that the alleged victim made contact with so many people that night, but only the victim testified. That's a problem.
Oh, it's very problematic. It's very problematic because if you are, as the state, like I said, you never want to hide the ball from the jury. You want to bring them the full platter and allow them to deduct which pieces of that platter they're going to take in order for them to be convinced that you prove it, your case beyond a reasonable doubt. If there are witnesses out there, it's not only a responsibility for the state to make them available for the defense, it's also the defense's responsibility, if those individuals actually add to the credibility of their client, to make sure that they are available to testify and call them and continue to lay doubt on the case with the state.
One thing I noticed from that video, there was an exchange. If you watch that video where she stood outside the building, they were passing the phones around. It almost like they were sharing phone numbers. There was some type of, if you look at the video, you can see the guy passes her the phone. She shows him her phone. They're doing a phone exchange. So could there have been argument that the prosecution couldn't locate any of these potential witnesses who could substantiate her injuries in something else? As I watched that video, I never saw where she showed any of those people that were there with her that she had injuries on her neck, her hands, none of that. You don't see none of that in the video. Why is that?
So my question is, if she was passing her phone around, did the individuals have enough time to put their numbers in her phone? Because I didn't see that part. Maybe I overlooked it, but if
then we make sure we should bring the exhibit up. We should look at the video. We should look at what's happening.
If that would be my question. If let's say that they're passing this around and they're afraid for her and her safety, or some people are going to say, put my number in your phone. I'm going to be a witness for you. I'm going to make sure that if anything, I can confirm what happened to you. And at that point, if that is the case, hypothetically, guess what the state needs to do? Subpoena her records. The defense has subpoena power as well if there was any question to identity of individuals who that phone was passed around to. Maybe a phone number may have been put in there at some point and called.
So you make a good point. But that video is so crucial. It's so crucial that the jurors have asked to see a portion of it.
Yeah.
I said on Twitter, I asked the question on Twitter, why is the jurors honing in on the car footage per se, and then asking questions about the count 4, the sister harassment in the second degree. And our next guest chimed in on this on Twitter, and she's going to be on at 3:00. So whatever she's doing, she's doing it. But that raises a concern for me, and I'm a little nervous that they're honing on that and not the running video.
Well, you have to be jurors. There has to be one or two that may be the holdout. So that when you have jurors back there that are, you have what we like to call them rogue jurors, the ones that are not.
Why they gotta be rogue?
Because they are.
For prosecutor, they may be rogue. For defense, they may be.
They are the ones that are about to either blow this case for you. So we call them rogue jurors because they have.
Someone just said it's a verdict reached. Let me see if that is the case. Someone just said it's a verdict reached. So, ladies and gentlemen, let me check right now and see if there's a verdict reach here. 1 second. Stand by. Stand by. Okay. Let me Let me see what we got going on here. That would have been pretty quick because they just went to lunch. I think maybe someone just let's see. I'm going to check now. There is a verdict. There is a verdict. Ladies and gentlemen, there is a verdict. We are waiting for the jurors to return. There is a verdict.
No rogue jurors.
There
There's
is
no
a
more
verdict in
rogue.
Jonathan Major's case, and we are waiting for the jurors to walk into the courtroom. So this is
no more rogue juror talk.
Okay. No more rogue jurors. But we're going to dissect whatever the verdict is. Good, bad, or indifferent. We're going to dissect what the verdict is. The jurors the judge is not in the courtroom yet, but there's a verdict. This is a breaking news development. Shout outs to
source.
My source. Well, hold on a second. Why are you saying not guilty? The jury has a verdict. The verdict's not in yet. You're saying not guilty. We don't know yet. We're going to see. We're going to see. We're going to see. Stand by, ladies and gentlemen. It's probably going to take them a few minutes to get all the attorneys back into the courtroom. It's going to take them a few minutes to get the attorneys back into the courtroom. But what does this mean? The jury had the case for approximately. They had the case over the weekend, and now they've reached a verdict half the day in. And they came, pretty much the jury started deliberation around 11:30, 12 o'clock today. So what does this mean? She's waiting for the verdict, ladies and gentlemen. I'm asking, what does this mean, counselor? What does this mean?
What does what mean?
That the jury has reached a verdict in this time frame. Is that a good? Can you read this?
I mean, it could go. You really could never read it. What the state hates is what the defense hates is fast verdicts, because they want them to sit back there and comb through each and everything with a fine-tooth comb. The state like quick verdicts to an extent. It is not always going to work out that way. In this case, a fast verdict, I don't think it looks. I'm not too sure how confident the state is, based off of what the public we saw, as it was going through what they were going through in trial. So I wouldn't be confident if I was the state and they came back this fast.
Well, do you think was it really fast? Because they got the case at around 2 o'clock on a Friday, and then it's almost like it's a day.
No, well, they've been at how many days were they in trial?
They were in trial for about a week and a half, maybe.
Yeah, that's fast. Typically, trials of that nature, that it's not a dead body, nobody got seriously injured, these people walked away and resumed their normal lives.
Okay.
Normally, trials like that last about 3 to 4 days.
Okay.
At max. Murder trials last a week and a half. And that's on a good low-end murder case. This lasting that long and them taking this amount of time to come back after being in trial for an extended period of time on these type of offenses, that is a quick return.
Quick return. Okay, so we're in pins and needles. Based on you seeing the case, covering the case, watching the case as it unfolds, what do you think the decision is going to be? No pressure.
I feel like I'm about to be a parlay legal expert. I'm on a parlay list for this case.
Absolutely.
And let me get my parlay together for this.
Jonathan Majors has been found guilty on 2 counts of domestic violence. That is the breaking news development. Jonathan Majors has been found guilty on 2 counts of domestic violence. The jury's convicted Jonathan Majors on a split verdict, and Jonathan Majors has been found guilty of domestic violence. Wow. Boy. Ladies and gentlemen, this case is obviously going to be appealed. I don't know what the judge is going to decide as far as, will they remand him, probably keep him free on bond because it's a misdemeanor case. He doesn't have a criminal history. What do you think is going to happen?
You don't typically get remanded on misdemeanor convictions. Now, New York is a little different. I'll tell you the states that are different: New York and Louisiana. Typically, they look different. So typically, he can bond right out on that while he waits to determine for sentencing, because they're going to have to do sentencing, and sentencing should go right into sentencing on some misdemeanor offenses. And I want people to understand that misdemeanor offenses are not the end of the world. He could have literally taken a probation plea on this and avoided going to trial. And
hold on one second. We have another breaking news update. Well, this is not breaking news, but we have attorney Akeisha El-Shabazz in the building. She's turning. She's about to spin in a chair, but she's here. As you know, we have a verdict.
Is there a verdict?
The verdict
is a verdict.
And he's been found guilty on 2 counts.
We're waiting for them.
Violence.
Shut the front door. Hold on, my dog's just barking. There might be somebody at my door. I gotta find out.
Ladies and gentlemen, this is real time. This is very disappointing. This is very disappointing. The jury.
Mailman.
Well,
all right, catch me up now. Sorry. Hi, Thelma.
Hi, Queen. How are you?
So
I'm good, beautiful. How are you?
About 3 minutes ago, the jury returned 2 counts of domestic violence. You did say
2 counts of domestic violence. There's no domestic violence. Assault,
well, not domestic violence, but aggravated assault and what's the other charge? Hold on.
Aggravated assault.
Assault. What is it? Assault?
Yeah, it should be
assault, not aggravated assault.
Yeah, DV
and harassment.
And harassment. Been found guilty of 2 counts. 2 counts of.
There was only 2 counts, right? How many counts were there?
Well, was it split? No, was it only 2 counts? I thought it was. Hold on a second here.
I thought it was 2 counts.
Hold on a second here.
Was there 4 counts? Let's find out. Let's see.
Why I think it was 4 counts, and they split it. Hold on a second. I think it was 4 counts. Hold on a second here. Okay.
Guilty of assault. I told you I'm a fucking. Yeah, I wanted to be wrong. God damn it.
4 charges. Yes, 4 charges. They split it, so it's 4. It was 4 counts. Yeah, but you did say that to me earlier, Ike. You did say based on the 2 readbacks, the questions that they had earlier, it wasn't looking good.
Yeah.
So, as you being a former Manhattan prosecutor, what does this look like as far as a sentence? Will they try to remand him? Will they give him probation? What is at stake?
It's a misdemeanor. They're not going to try to remand him. This is what I'm going to predict what's going to happen right now. They're not going to remand him. Jonathan Majors is not going to go to jail. He's probably very likely going to go in and make an application for bail pending appeal. If he gets sentenced, he should get bail pending appeal on a misdemeanor.
Yeah.
So it's not over. The fight is not over for him.
What is he facing in as far as time? If he was
He's facing a year on each count. So if
Yeah.
he's convicted on 2 counts, then he's facing a year on each. The judge could run them consecutive. So
Mhm.
he's facing 2 years. Likely, this is going to be a definite sentence, meaning that he's going to serve this time in the beautiful confines of Rikers Island.
Mhm.
It's not a state bid. It's not state prison.
Wow.
He's not
Yeah.
going. He's not going upstate, which is unfortunate because Rikers is so much worse than a state jail, than the
Oh,
state
it is.
prison.
I've
It
heard
is,
so many
yeah.
horror stories.
It's awful. It's awful. I'm, firsthand accounts. I'll tell you, it's not where you want to be. It's not where you. I've had clients who have pled guilty, and it's like, hey, hurry up and let me get sentenced. Put that on right away, or we'll waive pre-sentence report. I need to get upstate as fast as possible.
And those are felony
Because it's
convictions,
a
obviously.
process. Yeah. Well, it's a state time.
Mhm.
Oh boy, so I mean, his career. What does this look like for his career?
It looks like the end of his career. It looks like the end of his career, unfortunately, at least until, we can find out what's going to happen with his sentence, whether or not he is. No, the judge could give him probation, right? The judge could say 1 year. He's facing up to a year. He could get no jail, right? The judge could say, okay, this is your first offense. We recognize you're doing great things in the community. We've got some mitigation here. We think it's best served if you do some community service, attend a domestic violence, workshop, class, whatever may have you. There's a whole range of possibilities that they could fashion as a form of punishment that do not include jail, right? It just remains to be seen what happens. I can't imagine he was remanded today.
No.
I can't imagine. I can't even see that. Yeah. I can't see that.
Well, this people are looking at
I
this
hate
case.
to be right.
Yeah, they're looking at this case and looking at the evidence that came out, and they're wondering why did the Manhattan DA even pursue this particular type of case when it appears that there was some form of. It appears that there may have been some form of culpability on both parts.
They do that. Mean it's obvious why.
Right. That doesn't.
You are.
Even if there's. I'm sorry. Go ahead.
You are the biggest star on this planet right now, and you are a Black man. So you already know they want this on their resume. Misdemeanor or not, they want this on their resume. I've seen it. I've lived it. I've been a part of
what.
Go ahead, Ike.
Now, I was going to say, I think people tend to believe that if two parties are engaged in some sort of altercation, that somehow that absolves one party, right? It doesn't mean that he is exculpated, meaning that he is not involved or does not have any criminal liability simply because you think she does also, right? That's just not how that works. And simply because they didn't pursue the criminal charges against her doesn't mean that they can't pursue the criminal charges against him. We know the system isn't fair. It's never been fair. And I've been screaming since I've started doing videos about the discretion that prosecutors have when it comes to bringing charges, right? And I even liken this to the subway stabbing. Remember the Marine who stabbed the Black guy on a train?
Absolutely.
Right. And they did not charge that man. They didn't charge him for weeks until the public outrage, like, hey, you're just gonna let him get away with murder, right? And then they charged him, and they charged him with manslaughter. But what it showed was that they have the discretion. They get to decide when they want to levy charges and when they do not, right? And so this is where we are. It's never been fair, right? So that can't be our argument. We can't always run to the whatabouts, right? Because that doesn't do anything for us in the moment. It just doesn't. It doesn't help our argument. It doesn't further our cause. What about Grace? Okay, what about her? He's still guilty, according to those 6 people in that jury room.
Yeah.
Right. And we don't know what the testimony is. Remember, when I posted, I said, Dennis, according to what's on social media, right? I don't see it, but I didn't hear her testimony. I didn't see her testimony. And that's a very different experience. We don't know what she said. And they allowed in the history of this relationship for a reason, right? The fact that they allowed in the audio of him saying, you got to be like Coretta Scott King if you want to be with me, blah, blah, blah. They set up and painted a picture of him in this relationship as someone who was manipulative, controlling, an emotional terrorist. You text him that you're going to unalive yourself and things of that nature. She's texting it back. This is the most toxic relationship you want to have, right? And so this is where toxic relationships end, with the man in jail. Coming, Jonathan Majors, you didn't see that coming, right? I mean, it's the history of America, is it not? Yeah, so I'm not surprised, and I really don't have a lot of sympathy for him. And I think somebody better get Megan Good some good running fucking sneakers. get on some good running sneakers. That's all I'm gonna say about that.
One thing that I don't know if this happened, but your legal team have to have a come to Jesus moment with you. When you know,
say that again, sis.
They need to have a come to Jesus moment, because to me, this goes in line with Tory Lanez also. If I know my client has done things that is going to come out, we need to have a conversation. And the conversation is going to be that you need to tuck your tail and take responsibility. Because if you don't, and you go before a jury that is going to judge you, and things that are going to come out that you don't want to come out, be prepared that they are going to go back there and they're going to use that against you, whether it's a part of the law or not. The judge tells jurors all the time, you can't use certain things to come to your decision or for your verdict. They don't do that. They still use the emotions behind it. So this legal team, I don't know if they did. I'm not going to say that they didn't, but you have to have these come to Jesus moments, and these individuals who know that they have culpability behind what happened. They have to come to the realization and get out their power high horse and thinking that you are above the law to where a jury is not going to see through it. And you're going to have to take responsibility. If you take responsibility early, guess what? The sting does not sting as hard as it is going to sting right now.
So basically, there was a miscalculation by his defense team in pursuing how to get this case resolved.
Yeah,
we've seen a lot of stuff come out early on from his team, and some of it was probably intentional. But the other question is, did they know everything they knew when they were out there perhaps trying to reach the public versus strategizing on the inner workings of their case?
So,
this is why.
Go ahead. Go ahead.
I was just going to say, this is why the same argument I made in the Tory Lanez case is that defense attorneys need to learn that you do not get in front of the evidence. Like, shut the fuck up. You have nothing to prove. Why are you releasing text messages that you think are helpful to your client, but are not? Right? The text messages that they released, those were the most indicative of a abusive relationship if I've ever seen one. Right? So that wasn't helpful for your cause. Why are you got him running down to file a complaint 3 months after the fact? That just makes you look vindictive. It makes it look like you are not a real victim, but this is part of your strategy. Again, all of this makes you look bad. And so she tried to get in front of the evidence, try to head him off at the path, writing letters to the judge. Then shut the fuck up. Just like we tell our clients. Now we got to tell lawyers, when you get in front of the cameras, shut the fuck up. God. Let your client have his day in court when that happens. It's bad.
It's almost like
but
there needs to be a crisis management. It's almost like there needs to be a crisis management team for the defense team, that is
Right.
going to tell the defense attorneys to shut the hell up.
Shut the fuck
Because
up.
if
Yeah.
you don't, you are going to ruin it for your client.
Yeah.
And I'm sick of seeing is defense attorneys playing PR. You did not
Yes.
go to school to be trained to be a public relations expert.
Yeah.
You went to
Mhm.
school to learn the law, know how to apply it, and go out there and be effective for your clients.
Right.
And this is what's pissing me off with these defense teams, because they think that, of course, the media is going to tell their story. Yes, they're going to tell a story, but guess who's going to judge the story? The jury. That's who you got to convince.
Yeah, only
You
the
don't have to
jury.
convince the
Yep.
public.
Yep.
Well, you do know that part of
Mm.
their strategy is to reach a potential jury pool early on before there's a jury pool even picked. So, but that's filtered out during a voir dire, you know.
That don't mean nothing these days. Because let me tell you something.
It
Everybody ain't
really
showing up for
doesn't.
jury selection. Us, especially, we're not showing up for jury
That's
selection.
right.
So guess what? You're going to get the individuals that are who are very, very enthusiastic to come and sit on the jury that don't look like us. And guess what?
And you don't want them.
It only takes one to go back there
Yeah.
and play politics and play like the commander in chief, and it's going to
Yes.
indicate and dictate what is going to happen.
Mm.
Yeah, you can't. That's why
I see that now, even with the young Doug trial.
Mm-hmm.
And when the Judge Glanville is asking jurors questions, it's one woman there
Mhm.
that always asserts herself. Yes, Your Honor.
Right.
We heard. Wait, whoa. It's several of us in this room here. We heard you. Like, wait a minute. She's just forming. I'm watching that too.
She running
I'm also
things.
watching the guy who's always
She
asking
running
for free
things.
food.
I really think that this matter
Wow.
could have been handled so differently. And it's the same thing I said with Tory Lanez. His situation was different because he's facing deportation. What his team should have, instead of trying to chase the story and trying to reveal the real story, they should have been working something out on the probation side. And it is not unlikely. This case did not result in heavy injuries. And what I would have done is been strategic, because now she has a pending case. He had a pending case at the time.
But you know, her case is not pending anymore. They dropped it.
Well,
her case was never pending.
No,
they never picked it up. What you mean they dropped it?
But
they never picked it up. You dropped it. Right.
Okay. Well, you have these two individuals who are basically beating each other up. And you taking responsibility, whether you are starting with taking classes, you're going before, domestic violence conferences within this time, you are creating that narrative that is going to show that you have the ability to be rehabilitated. So when you go and you ask for probation, because he should have asked for probation, I would have asked for probation that didn't come with, I know in the state of Texas, we have affirmative finding of family violence that really ruins your life. I would have asked for, if that is the same in New York, I would have asked for that to be removed. Okay, well,
we don't have that.
That's even better, because Texas, they known for, they gonna ruin your life. You can't do nothing with affirmative finding. You can't get a gun. You can't be a lawyer. You can't be a doctor. You can't be a nurse. You can't be a teacher. It's a lot of things that you cannot do with that type of finding. And if you ever get arrested and have a handgun, the feds can pick it up at that point. That's how detrimental it is in Texas. But he had the ability to show rehabilitation, take responsibility, ask for probation, and move on with your life. Take accountability and ownership. That's what people respect the most. You had a moment. The moment got out. You did something that you normally would not do, but you did it. You made a mistake. Own up to it. Take accountability. Take responsibility, and move on with your life.
If you had to give his team advice moving forward based on the outcome of this case, what would it be as it relates to? I mean, you already know the jury came back with the decision. Is there anything more you can do as his attorney to help him? I guess get a better outcome with the judge? Maybe, I don't know. What
Mhm.
is there any negotiation power? Do they still have any type of negotiation power at this point? Anything?
Yeah,
Yeah,
yes,
you still
because
do.
of course.
They can still
Of
agree to
course. I mean,
probation.
it's well, no,
This is why I keep-
well, yeah, they could. The range that he's facing is no jail to a year. So anywhere
Mhm.
in there is the room to negotiate. That's the wiggle room, right
Yeah.
there. And I'm not a fan of probation personally. I don't tend to like to have clients on probation. I think it's just a lot of rope that they often hang themselves with, right?
Mm,
So I try to fashion other remedies, right? So maybe we could use this person. This is Jonathan Majors. He's a major superstar, right?
right.
He could be
You can do a
he could be
PSA,
useful.
style
He could
PSA,
be
like
right. He
TI.
could be useful in so many ways. My
Right.
other question is, why didn't he take the stand? You a whole actor. You a whole actor.
I said,
That
I
was
was thinking that this morning. I said, why did he take the stand?
I'm
This is a
not making
misdemeanor
light
case.
of this man, but
If you
you a
couldn't
whole
deliver those
actor.
lines,
So why
and
did he
that's what, and
testify?
whether we like it or not, and whether
Right.
juries
You
want to
can
admit it,
come up with that.
juries do take that into account, even though they say that they don't. They do.
That's right. They,
Mm.
they do. Because I'm sure they wanted to hear from him. This is one of those cases where jurors want to hear from your client. And there are many times where you will not even consider putting your client on the stand. This is one
And
of those
Rick
cases
said
where
what
I would
Mr.
have been
Rick
like,
said.
listen, you might need to get up there, talk about this and explain some things,
And
right?
he
At
said
the
take
very
his stand
least,
so they can bring out his prior bad acts.
what prior bad acts? They came out already. The prior bad acts were out. The phone call was out. The prior relationship that they had where they had this, little tiffs and taps, all that shit was already out.
Yeah.
I don't know any other prior bad acts that he has. I mean, prior convictions and things of that nature.
Right.
That stuff was out.
Right.
The judge let that stuff in. So why not get on the stand? At the very least, you get a hung jury. You only need one.
You only
need one. Put on your best acting skill. Cry too. You was a victim. Explain it. But
because at that point
if
it
you
all
don't
comes
do
in.
that,
Because they don't.
there's nothing for them to counter it. Yeah, to counter the people's case.
Mm-hmm.
Who the defense? I'm curious, Thelma, if you know, who did the defense put on a case?
I need to find out because I need to be emailing them so I can help them with their strategies moving forward.
Good luck with that. I ain't about to help nobody.
Because clearly, the defense teams need to be policed.
They really do.
Because I'm just like,
Rick said he did cry. He did cry as his defense lawyer was doing the closing argument and was explaining to the jurors that he was trying to run away.
Too late.
And it's too late, right? Because I know they were like, "Oh, you crying now? You crying now?
Get your big butt on this stand.
Thank
and
you.
Cry.
Cry in front of
us.
us.
The same waterworks that she put on.
That she did. Thank you. What happened to that? I don't understand.
You got to cancel the tears out. Cancel the tears out. Now they only got one set of
That's
tears.
right. Trauma got to meet trauma.
Yeah.
Right? And he's got to talk about everything he's losing and could lose as a result of this.
Yeah.
Right? So that jurors understand the consequences behind a guilty. All of that matters.
They care about that. The jurors care about your life. They want to know these details, these intimate details, so that they can have a personal relationship with you when they go.
I did wonder why he didn't get on the stand. Was there a reason why they didn't put him on the stand? I mean, it would make sense. This is a he say versus she say. You both get to tell your story. Get a chance to tell your story.
Right.
I
you filed a complaint. Well, you get to talk about that.
Right.
The judge said that could come in, right? So,
ladies and gentlemen, I do see all your comments. There's so many coming in.
Why come I can't see him over here. Oh wait, let me see.
Can you see him? I can see him. There are a lot of them. Let me see.
Let me see if I can see comments.
Okay, so I want right
Hold
now
on,
before we
click on
start reading comments,
I got them now.
I want you guys to make sure you're hitting that like button. You know, this is important. Hit the like button so so we can make this video, get through the numbers it should be doing. And you can see there, you see the follow all the handles here. And wait a minute, let me see what we got going on here. Hold on. Let me make sure we see what we got going on here. Yeah, make sure you follow everybody here. Mikey, I was I didn't think it was going to be this outcome. I really did, Mikey.
You didn't listen to me. You didn't listen to me.
I listened to you. I listened to you. Let's say I was hoping it would have been.
Oh, you thought I was wrong.
See, you go. See,
no.
you see, Thelma. See what she's doing.
I
got two prosecutors here, ladies and gentlemen. So
I taught you to manage your expectations. I know I taught you that.
Listen, can we talk about managing expectations? Because people don't understand when you get in a trial, shit happens. And at that moment, you got to manage some expectations during trial because the shit be going down. And then your case be blowing up from left to right. And you'll be like, God damn, I know I did a right assessment. Then you got to adjust. And then you still have to manage your expectations throughout the process of the trial because everything changes. Nothing stays the same. It's not going to be perfect. It's not going to be consistent. But you got to know how to adapt.
Yeah, I agree. CNN just said sources stated that with 2 convictions, he'll probably be dropped by Marvel. Oh, yeah, this is what I'm saying. It's all downhill from here, right? Because who wants to be associated with the violent domestic abuser? Who's putting him on their set, right? What liability insurance company is going to be like, yeah, we'll insure Jonathan Majors on the set? Let's think about that, right? These they need insurance on these sets.
Tyler
they
Perry,
might
Tyler
not
Perry will put him. Tyler Perry will put him on. 50 Cent will still put him on. We already know 50 Cent is the one.
I wasn't ready for this. I wasn't ready.
I'm just saying we already know who is going. When in
doubt,
call 50 Cent. When in doubt, call 50 Cent.
Jonathan Majors is. I think that I think he's a little presumptuous. I think he thinks he's above that type of acting credit. Like he's not a power guy. You know what I mean? He's A-list. You know what I mean? I don't think he's gonna want to be on Sisters or whatever. Tyler Perry.
You gotta go where you are welcome at this point. You gotta go where the doors are open and where the checks are being paid.
This is true.
I would say any villain role, I'm sure he'll be okay for that. He'll suit
the villain role. So I'm not laughing. It's not funny about it. It's not funny about this. I'm not. It's dead. No. Somebody said Tubi. Tubi will take him.
Hell no. Not Tubi. To be continued. No.
Oh man,
ladies and gentlemen, damn. This is a very serious, serious case. But we have to look at the brighter side of this. That he's not going to state prison, and he may not do any time at all. He did have an option to pull the parachute, and that he could have took a plea. I'm sure there was an offer. And this he rolled the dice. At the end of the day, he rolled the dice, and he has the right to roll the dice.
Right.
In this case, it's snake eyes.
Right.
It's just something that boy. Oh my goodness.
Yeah.
This one.
Tough.
Yeah. Verdict watch is always. It's always nail biting. The verdict watch. Right. I don't watch so many different verdicts, and this one here was like, wow. It wasn't a felony case. Stakes are high. This is his career. This is what he was fighting for, his career.
Yeah.
Right.
No different than Tory Lanez was fighting for him not to be deported.
Mm-hmm.
Right.
And it actually happened. He's not only he's going to be deported, but he got 10 years.
First,
before he goes
before they deport him, we gonna get 10 years out your ass. That's crazy.
Yeah,
it's not crazy. We just pause for a second. That's how this works here when you are an illegal or an immigrant or whatever, and we are going to deport you because you have committed a crime in our country, we first say, let us make as much money in the prison industrial complex as we can off your ass before we ship you away. Ain't that some shit?
It is insanity. And you know, immigration.
Send my ass, excuse me, send my black
it costs more to defend an immigration case than it does a regular case.
Right.
The price triples.
We have to pay for this for 10 years.
Yes.
That's
the craziness. It's $1 billion industry. Prison industrial complex. Okay. Yes, sir.
I call it high
my fan on. I'm over 50, goddamn it, and it's hot.
Let's just say what it is. It's high-tech slavery.
Fucking hot.
You know, girl, what you got going on there?
Yes, horrible and sad. I'm over 50, goddamn it. That's all I'm gonna say about that.
Okay.
Listen.
Shit.
Oh my goodness. Let's read some.
You better let them know. You better let them know.
Okay.
Okay, hold on. We gotta go on work. Okay, but look what they said. They made a good point here. This is a good point.
What?
Listen.
Columbus Short. What part you got? What? Okay, tell me what's the last thing Columbus Short was in?
Listen, I really don't. Columbus Short. He's
not in Marvel. He's not doing Marvel. He's not doing the big shit. He's not A-lister anymore. Right? So yeah, he can get work. Right? I'm sure he can get work, but he's not getting that work. He's not that dude anymore.
Damn, this is
listen. Listen. This is not true. Hold on a second here. This is someone said this, Ike. This is funny. I think this is funny here. Dennis, you're batting zero.
Kelly story now, John.
The roast is real, ladies and gentlemen. The roast is real.
That's because you don't listen to me.
I was going to ignore that.
I'm
going to put you on front street.
I love it. That's funny.
Listen, hold on. I knew Tori's going to be found guilty. Okay, one. I knew R. Kelly was going to be found guilty. Two. I didn't know John. Don't do that. Let me get this guy's comment on. Get this person's comment off the page.
Where's Pam? I thought Pam was coming. Columbus Short was never Marvel level. Exactly. This is why we cannot compare Columbus Short. Thank you, Barbie Balboa. We cannot compare Columbus Short to Jonathan Majors. We just can't. Majors was major.
Right. Oh, man.
He was major, and his future was looking bright. It was.
Thelma, do you have a Twitter account? They want to know if you have a Twitter account.
No, y'all. I have not been on Twitter since I took the bar exam in 2015. I gave up Twitter because, one, I had to give up social media in its entirety because the Texas bar exam is a beast. And I just got rid of all social medias. I never reactivated my Twitter.
That'll be changing soon, ladies and gentlemen. What was it?
I know.
You on IG?
Huh?
You on IG though? All right,
I'm on IG. Laurier Bay ESQ.
Okay, you want to set that Twitter because it goes down on Twitter.
I know it goes down, but it's so much like I can only take so much social media in before I get overstimulated and I just draw back. And it's only so much. And Twitter is a wild place.
Same.
It's not the same. And I be it goes down too much in Twitter land. And I'm like,
it really does.
Shoot.
Yeah.
It goes down.
You think Twitter's the Wild Wild West?
It is like look at the owner. Do we expect anything less?
Right.
Okay, so I'm gonna read another comment here. Let's see here. I'm not going to read too many comments. You guys know what you see the support the platform. We're not hitting too many comments here. I'll pull one or two out.
People will never give him a second chance. People will give him a second chance. Just define people, Kevin. Like, who are the people? Right? You know what I mean? Is Marvel the people? Because they may not give him a second chance, but we will. Like, we will.
We pay for You know, we faithful to our
Of
people now.
course. Of course.
You mess up, guess what? You still come to the cookout. You still gonna get your bottle of Hennessy. On the rocks. The barbecue with the Uncle Sandals gonna be popping. So yeah, we are a very forgiving community race. I think we are the most forgiving, in spite of everything that we've encountered in this world. So Jonathan, when it comes to his community, of course we gonna have his back. But we ain't got the money to give him his money back.
Well, I don't know. You may say that go. I think if you put that GoFundMe up, I think that thing will probably light up like a Christmas tree. As Jonathan
listen, I'll definitely give him about 2 pieces of crackers.
I don't know. I like to see it. I like to see it.
Oh wow.
I like to see it.
What is Jonathan's net worth anyway? Do we know? Anyone know?
Harper, wait a minute. Candy Eyes says she is not a good fit. This is talking to me. What is with all the foul language? Thelma, don't lose your respect with this other lady. Yes, Thelma, do not curse like me. I curse like a sailor. I ain't gonna change a motherfucking thing.
Something.
If you are more offended by my delivery than what I'm saying, then check yourself. Check yourself. Check yourself, because my language is selective, because I'm outraged most of the time when I'm talking about the things I'm talking about. And my vocabulary is expensive. The words that I choose are my doing.
And ladies and gentlemen, she is very good at what she does in the profession.
So understand that, Jenny, I'm an intellectual first. And I'm a college professor and a law school professor. So understand that the switch up is real. We all understand that we code switch. Yeah. But when I'm on Instagram, I'm just talking to people, regular people. I'm not lawyering. So, yes, I'm going to say fuck a lot.
That's right.
So, and I'm going to say Candy, that's fine. That's fine.
And I'm going
Thank you, sis. Appreciate you.
Because that's one of the things that I think a lot of people don't understand. They want lawyers to be robots. We ain't robots. Right. We got a life outside of this. And guess what? Right. We need to start, more of us need to start being our true authentic selves. That's right. Because that makes us more relatable, and it makes individuals not so afraid to approach us when they see the human side of us. This a profession ain't gonna make me no robot.
That's right. No. In other words, whoever that person was, kill that noise.
You should drop the bomb when you missed your cue.
They don't want to see the other side. You listen.
You missed your cue to drop that bomb.
Listen, she just dropped it.
I know.
She dropped it already.
Let me tell y'all something. You do not want an educated Black woman to read you. You don't.
Oh no, I got.
You don't stand a chance.
We got one more up in this building. We need Gerald. You need to get up here, Gerald. Get up here, Gerald. We got Gerald Griggs here.
Lawyers are real people.
Yes, we are real people. Absolutely.
Now Gerald will come up. Gerald, listen, Gerald, you need to get up here, Gerald. That's another one of my great attorney friends. The head of the Atlanta NAACP in Georgia.
All right.
In Georgia, he's here. You need to come on up in here, sir. I don't know what. Let me drop the link for you.
Send the link.
Let me send the link. You want to play?
Shawanda said Jonathan Major's net worth is $2 to $7 million. That's not a lot of money. I'm assuming that this defense cost a couple $100,000
for a misdemeanor. For a misdemeanor.
Yes. And it's not over, right? It's not over because, again, like I said, there's got to be that application for bail pending appeal. That's a process. I actually just did one in Nassau.
At the end of the day.
What'd you say?
I'd say this is costing a whole lot right now.
Yeah. It's
Gerald,
expensive.
I'm sending you the link, Gerald, to your phone.
It is expensive.
I dare you come in to try to correct my guess. The nerve.
It's all good. I love you. I really do.
They must be new to the platform.
That gotta be. That gotta be.
They must be new. Okay, yeah, I just sent it to them. So Jonathan. Oh man, Jonathan. what did you? It's like I'm looking at the video again. The evidence that was actually sent back to the jurors. It's about an 8.5 minute of evidence and video clips and so forth. Do you think that they should poll this jury? Should poll this jury that asks, why did you guys come up with this decision?
Well, that's typically they don't do. So typically the polling only asks, is this your verdict? They don't ask, why is this your verdict?
Mhm.
Right. And typically polling is done if the defense requests it. Right. So the judge is not going to poll a jury on its own, usually like what we call sua sponte. They're not going to do that because one, they don't want to upset the verdict, but they will do it upon request. In the fact that there was no polling. Anytime there's a guilty, there should be a polling of the verdict, of the jurors, rather. Just to be sure that nobody got bullied back there, because that happens. Sometimes people get silenced. They don't have the fortitude to be the last man standing. And if you do not know how to do proper voir dire and you don't prepare the jury for that reality, then they will cave. Like one of the things that I do in voir dire is I ask them, listen, if the hour is late on a Friday at 4:00 and the vote is 11-1 or 5-1 and you're the last man standing, can you hold out? Are you going to cave simply because there are more of them and less of you? Right? Or are you going to stand on your sincerely held belief? Right? Because I'm not going to ask you to abandon something that you're just holding on it because you want to be difficult. But if this is your sincerely held belief, are you going to just abandon it because you are in the minority? This is what you got to go over on voir dire so that when they get in that back room and the shit get thick, they will be remembering the promises they made to you in voir dire. You promised me you wouldn't cave, right? And so that, that comes with, experience. I don't know if these lawyers know to do that.
I don't think so.
What are some of the things that
I don't think so, because it is what individuals don't understand. It is an art to doing voir dire, and you cannot be afraid to challenge these jurors during voir dire, because guess what? If you don't, you're going to get one that is going to freaking bomb your case. And guess what? When you get back there and you go over your notes, you're going to realize that's the one juror that you didn't ask that important question to.
That's right.
They do it all the time.
Now, and I also want to know if the defense attorney requested the implicit bias charge. So in New York, we have a charge that I don't know if they have it in other states. Do you have an implicit bias charge, Thelma, in Texas?
No, we don't.
Okay, so this is a new.
Oops.
Oh, you're right over there.
No.
I dropped the bomb for you. What I was gonna say, like I went to Brian Stevenson's Legacy Museum a couple of months ago, and he has this book, Race and Jury.
Race and the Jury.
Every defense and prosecutor needs to read this book because it talks about implicit bias. And it talks about how dangerous it is. And if you are not a defense attorney and you don't have this book, you are doing a disservice to yourself as an advocate, as a litigator, and to your client, because it's going to show you how you can overcome individuals who have implicit bias. You can pick out the individuals who have these issues, and you can also draw the attention to the prosecutors who are implicit in it.
Right. And so this is if you don't request this charge in a charge conference, and I know that, we have a lot of people who are fans of legal TV, and they see charge conferences. That's when the lawyers are arguing what the court should tell the judge about how to look at this evidence, about how this evidence should be applied to the law. One of the things that you can ask for is an implicit bias charge. And some of the language from the implicit bias charge is the court in the final instruction will inform the judge, the jury. Some of it is like, we all develop and hold unconscious views on many subjects. Some of those unconscious views may come from stereotypes and attitudes about people or groups of people that may impact on a person's thinking and decision making without that person even knowing it.
Briggs.
What's going on, y'all?
How you doing, Greg?
Welcome to the jungle.
Man, I was just watching y'all on YouTube, and Dennis sent me the link, so I guess I'll join you guys and have this conversation.
Welcome. Right. So we were just talking about the implicit bias charge and whether or not it was requested in the Jonathan Majors trial.
The implicit bias charge? That what y'all talking about?
Yes.
Yeah. Okay.
Yes.
Go right ahead.
Yeah, I was just wondering aloud whether or not the lawyer requested it and whether the jury was given an implicit bias charge, especially in a case like this where, race is an issue.
Yeah, I think it should definitely have been requested. I'm not sure if his lawyer did or not. I really haven't been following this trial separate apart from, the news coverage.
We're going to get you a stand.
Yeah,
no, I left my stand at the
you
house.
need to get a stand. Your phone. No. Oh, wow. Okay.
I left it at the house yesterday.
Over here.
I literally did, y'all.
Morgan
is okay, that's better. Listen, tell the audience to buy me a stand and send it to me to get my P.O. box, because I know they care.
I got you covered. Don't worry, I got you. Okay, so you were saying Gerald?
Yeah, I think it should have been given. I think it probably would have been an oversight or potential, error if it wasn't given. I mean, this case does have race all over it. I mean, from the comments about her needing to be more like Michelle Obama or Coretta Scott King, I think that, you should have at least given the charge. But, you never can tell. I don't like to, armchair quarterback a trial after you, unfortunately lose. But, it's easy to look back in retrospect and say what could have, should have, and would have been done. But I did want to jump back to a comment that y'all were making earlier, talking about, lawyers are real people. Hence, I'm wearing a hoodie at work. We are real people.
Yes.
We have real lives. Yes. We're not always robotic and, conciliatory and use all those big terms. We are real people. So I appreciate the sisters for lifting that up. And, some of us, myself included, get a little potty mouth. I'm from Southwest Atlanta, so, don't let the food taste fool you.
Listen.
Right.
And I'm a project baby, so you already know what comes with that.
There you go. Wow, you really, Dennis? That's what we're doing. That's what we're doing.
Okay.
We hoodie professional team over here. Ike, you got to catch up, Mikey.
Yeah.
Hey, what the heck happened?
You just muted yourself and turned your video off.
The hoodie did it.
Hoodie. YouTube doesn't want the hoodie out.
Oh, wait a minute. What the heck going on here?
You gotta cut your camera back on. There you go.
I'm here. All right. So I couldn't see myself with the hood on. Let me take this thing off. Go ahead.
Yeah, but what do y'all think about the verdict? I mean, it seems like it was a split verdict. It seems like they didn't believe that he intentionally assaulted the young lady, but after he was trying to, recover his items, that's when, they are attributing criminality to his conduct. So what do y'all think?
So tell me that again, Gerald, because I thought he was found guilty of the assault.
I thought it was an addition, it was multiple charges. And I think the initial charge was the initial conduct. But I think they were saying, at least from the reporting that I'm hearing, again, I didn't watch the trial, but it was once he tried to retrieve his phone, the interaction that happened in the car and the bruising is what he was found guilty of assault. Am I correct on that?
I don't know, but here's what I will say. In New York, for him to be found guilty of assault, they had to have found that he intentionally caused those injuries.
Okay.
So the elements of assault are intent to cause physical harm. Intent means to be consciously aware, right? So there's not a negligence, it's not a reckless, it's not an accident. It's that it is your goal is to effect this harm. The harm being whether it was the injury to the finger or whatever. I think it was the finger or the neck, right? Maybe that was the 2 counts because there were 2 counts of assault. So physical harm could have been the fingers and then the scratches on the neck. So you intended to cause those injuries. That's assault. There's nothing else there.
I guess I was talking about the
Reckless
acquittal on
assault
the
and
other two,
harassment.
the other 2 counts of assault and the aggravated harassment.
Did they
So-
find not guilty, or did they find not? They found him not guilty.
Yeah, he was acquitted of
That's
2
what
counts of assault and aggravated harassment in a split verdict.
Hold
So
on.
what was he found guilty of?
1
Assault,
count of
Coach?
assault and
Harassment.
then 1 count of harassment.
And so
Oh,
the
1 count of assault. So the 1 count of assault is a misdemeanor. Harassment is a violation. That's not even a crime.
Wow.
Harassment is a violation. The aggravated, if it's an aggravated harassment, that's a misdemeanor. But harassment in and of itself, if it's a 240-20 or 240-20, whatever, that is
Those are the penal
a
codes.
violation, not a crime.
So he
Okay.
actually
Harassment is 240-20. Harassment is PL 240-20 or 240-26. I mean, that's off the top.
He has a
That's
better
all.
chance now. Yeah.
Well, it doesn't say he's getting any jail time.
Assault is penal law 120, 120.00. That's off the dome.
All right.
that's
You
the
better let him know.
There you go. You know your
Now,
code
oh.
section.
About 20 years.
Okay.
plus.
Potty mouth and all.
Okay. I could curse and know the penal law. Candy.
At the same time.
Yeah.
See what I'm saying?
Yeah, it says the jurors found him not guilty of the most serious charge, the assault in the 3rd degree with intent to cause physical harm, as well as the aggravated harassment. So yeah, I mean, this is an interesting.
Aggravated harassment?
Yeah, aggravated harassment.
Aggravated harassment. Oh, okay. So, and then they found him guilty of, but then
The assault
that's
and the
misleading
regular.
because
So it says the person in the comments
is
says
misdemeanor assault.
yeah. So it says the person in the comments saying reckless assault and then harassment. And so, like I was saying, they didn't believe the initial altercation where it was
Reckless
intentional, but he might have injured her, putting her back into the car. Is what I read into it.
Okay. So now we're talking about different elements of your scienta, your mens rea, what you think. So we're there's this interplay between intent, recklessness, and negligence.
Yes.
Right. And so if they didn't find that he intended to cause the injury, they could have found that he recklessly caused them. Right. And that could be the lesser assault charge, right?
Yeah.
Recklessly causing. That means that you fail to appreciate that the activity you were engaging in could create a risk of harm. Right?
Exactly.
This
Right.
is
Fail
good
to
for him.
appreciate that.
This
It
is good
is.
for him.
And I mean, if you're arguing in mitigation for your client, these are good facts. So you can argue for
Definitely, that's
probation
better.
or
Absolutely.
some type of lesser punishment. So I mean, it's interesting to watch. Like I said, I literally didn't watch the trial, but reading the verdict, it seems like that the jury was struggling with some issues
That
in the
video.
prosecution's case. Yeah.
Asking for that video.
So that makes sense then. So they were struggling with the intent element. I think that's why they wanted to look at the video and zoom in so that they could see whether or not this was an intentional act or whether or not this was something that happened as a result of, just.
So him placing it in the car in that manner
was reckless.
Was
That's
reckless.
what they're saying.
But her running into the street was reckless as well. He said he was trying to prevent her from getting hit.
She's not charged. Again, we can't do the whatabouts.
No, I'm saying
wait, is wasn't she charged later?
No.
So here's what happened. This incident occurred, I believe, sometime in March?
Yes.
Jonathan Major, and some 2 to 3 months after the fact, went and filed a complaint.
Oh, okay. Okay.
At that point, it looks completely retaliatory. The only reason you're filing a complaint now is to help your case because now you've been charged, right? Because it's not contemporaneous with your complaint. If you're saying you were a victim, then at that time, why wasn't there a cross complaint then in March? right? And so the DA's office, and I'm a former prosecutor from Manhattan, so I feel like I can say this with a little bit of I feel like the prosecutor's office said this is just a revenge filing, and we are not going to we're not going to prosecute. And they said from the gate, they told the police this had no prosecutorial merit. We're not going to prosecute even if you arrest her. The police arrested her anyway because CompStat is a thing. That's a whole nother thing, right? CompStat and the police, when it comes to statistics, and they need to show that they are making arrests and that crime is down. That's how they tell you crime is down. You know why crime is down? Because they arrested fucking Grace Jabari. So now they can report that crime in that area has been solved. It's down. Okay, so they make the arrest, and the DA is like, yeah, we told y'all not to do that, and we decline what's called a DP, decline to prosecute. And what's the point of that? That came up at trial. That came up. It came out. Right. So
now
we kind of sense.
If we look at more sense. If we look at the way the jury reached a decision and what they looked at, this might help his career somewhat.
Oh
yeah. It's not what the prosecutor was trying to get. Right. This here, he can say, listen, I may have been reckless, picking up, putting in the car, but I was, he can put a story around that. But if he would got convicted of the more serious one, that's intentional
assault.
Right.
Yeah.
They didn't convict him of that. So that's
the other side of that, though, I think it's harder for him to appeal a reckless. You know what I mean? So we're talking about his options for appeal. Reckless is such a low standard that, if the jury came back and that was their assessment, I doubt a higher court would disturb those findings.
It makes even more sense of him needing to testify because of that. If he would have explained that reckless would have went away and they would have understood why he did what he did.
Yes, Helma. Yes.
Yeah, but you always know there's that risk when you put your client on the stand. They dig a hole that you cannot get out of. So I can understand the lawyers' calculus and not putting him up there because they probably felt that the evidence was not strong enough to convict. But you always open that door because you know what the jury says. The jury's going to say either I believe your client or I believe the state. You don't ever want to get into that back and forth.
Yeah, you do run the risk of shifting the burden when you put a defendant on. But he's not your average defendant.
No,
he's not your average defendant.
He's the biggest Marvel star of
exactly. So I wouldn't operate in my normal capacity with the average defendant, right? Because this guy is coachable. He can
remember your lines, sir. Remember your lines.
He's a great
cry on cue. When I
blink, cry on cue. Come on,
I blink, cry. That's a good one. When I blink, cry.
Whatever you need to do.
He might have got an acquittal if he would have testified. If he would have testified, he might have got it all the way away.
Yeah. That's what it sounds like. That's
or got dug a deeper hole. You don't know.
There's always a possibility of that hole getting deeper.
He's definitely a better position.
It's a possibility that you run the risk.
Now, Gerald, you were
worse.
In the courtroom, and this is we're gonna shift a little. You were in the courtroom for the Hannah Payne case.
Yes.
You were there. You were able to see her testimony. You were able to look at the jurors. You were there, front and center. Yes. What did you think about the way she testified and how the jury, was reading her? Because you saw the jurors during the whole testimony.
Yeah, see, that's why I was saying it's always difficult, decision to put your client up on the stand because Hannah Payne, for those who don't know, Kenneth Herring case, 2019, was having a medical emergency, ultimately had a car accident, waited 20 minutes for law enforcement to arrive. Law enforcement didn't arrive. He drove off. Hannah Payne, a bystander, chased after him, boxed him in, ultimately physically assaulted and then shot and killed him. But she testified. And in the testimony, you could watch the expression of the jurors. And again, it was 10 African Americans, one Caucasian American, and one Hispanic American that were listening to this. They showed no real remorse for her. She was crying. She was doing all kinds of stuff, conflating what actually happened. Got caught in her statements on multiple times. And so she really did herself more damage. And so in a case that lasted for a week and a half, for a jury to come back in an hour and 30 minutes, especially when they got the case at about 4 o'clock on a Wednesday and they had a verdict about 6:30 on a Wednesday, that tells you how much they weighed the defense's case. I mean, the state put together a great case. They had video. They had 3 eyewitnesses. They had Ms. Payne's statements to law enforcement on multiple occasions. And so that's one of the reasons why you don't put your client up, because, you know, a seasoned prosecutor would cut your client to shreds.
Oh. And
But
she
you
was
know what?
such
Let
an
me just
easy
push back
one,
on that,
though. She
Gerald,
was
because
such an easy one.
Go ahead.
it depends on what your process is, right? Because I know you or Thelma, if you were representing Hannah Payne, her testimony, her attitude would have been completely different. She wouldn't have been up there sort of facing off with the prosecutor, if you will, right? It should have been, this was an accident. It was, I'm sorry. There was no apology. There was no contrition. There was none of that. In fact, she was defiant, right? And so she made that jury hate her. That's why they came back so fast. She wouldn't acquiesce to simple points like, you cut him off. Here's your car right in front of him. And she's like, I was going straight. This is not the time for you to play coy with the prosecution. Say it. Yeah, I cut him off because my intention was to try to get him to go back to the scene. I never planned to this. I didn't hear that. I didn't hear any of that.
And I mean, the whole defense strategy was flawed from the beginning. I mean, you know, to argue that Mr. Herring was the reason for his death, it would have been easier case to say, I did not intend to shoot him, not that he shot himself. So, I mean, and then you're right. She was literally fighting with the prosecutor on cross-examination. So you could see who Hannah Payne really was in real time.
Right. This is what prosecutors do on the inside when defendants are fighting with them. We're like,
especially in the murder case. Oh, this woman's violent. Thank God she doesn't have a gun on the stand.
You know, look how she was treating me, and I'm just the prosecutor trying to get the facts.
I'm just trying to do my job.
She was angry. She was defiant. Imagine what she was like back in 2019 after somebody had cut her off or had a car accident with someone. She felt the need to take the law into her own hands. When I heard the closing statement of the prosecutor, and brilliant young prosecutor, when she said, all my life, I imagined being a police officer, I was like, this lady's going to prison. Right then, it was over.
Their team, they did an amazing job with such a difficult defendant who lied on several different occasions. They had so much to impeach her on. So much. And you rarely get a lot of things to impeach defendants on, but she gave them so much to impeach her on and show her inconsistencies. And that's what I know that's what the jury also paid attention to, because jurors don't like when you lie. Because you, first of all, they in there putting their time to make sure that justice is served. And you sitting up here lying on several different occasions. This man lost his life for no reason.
Yeah.
Oh, your citizen's arrest should have been making sure he got to the hospital.
What was your take on her defense strategy of getting the witnesses to come on? Or what's that? I don't know what the witness was like. She has black friends.
You don't ever do that, especially in Clayton County. Don't do that in Clayton County. You know, Clayton County, for those who don't know, is a large majority African-American counties, like 80%. And so when you use the I have a black friend defense, that ultimately shuts down a jury. Like, listen, this is not about whether you have black friends. This is about what you did on that day. And so when I first heard them going down that road, you know, again, I was watching the jury. I saw them. When I walked in and I saw the jury, I was like, oh, she's in an uphill battle already. But then to go, I have black friends, you know, I have a black, you know, significant other. That's not going to play well, especially when there's a video of you, you know, threatening a 62-year-old elderly man, telling him to get the F out the car. And then the last witness who said she shot him and then said, now he needs an ambulance.
Now you need an ambulance.
Not I'm calling an ambulance, but now you need an ambulance.
Yes.
Now you need an ambulance.
So, yeah.
So what I didn't understand, Gerald.
Now you need commissary, bitch. No, I'm sorry. All right, okay, sorry.
Yeah. What I didn't understand is that while she had her friends come in to you know, during the sentencing, why wasn't none of her black friends there to speak during the sentencing?
Because they probably was ready to pull up on her too.
Well, that's interesting because, you know, a few of them were in the courtroom. So I don't know why they didn't call them, you know, to the stand. And I do know her boyfriend was there for a majority of the case. You know, you would have thought you would have called him. But, you know, you never can tell. They sat through most of the trial. So, you know, maybe they heard a different side that they hadn't heard before. And I mean, the videos were quite disturbing, to say the least. You know, again, the video,
Carly Richardson moment. Hey,
yeah, the video. I don't know. Don't bring up her, but the video of her approaching the vehicle. And here's what people don't understand: she approached the vehicle, knocked on the window, and then produced the gun. Was wailing on him in the car, and then kind of looked like there was a struggle, and then she stepped back and fired. That's a problem.
That's right.
Right, because I don't understand if that's the narrative, Gerald. How is she claiming that he fired the gun himself? Like he had his hand on the trigger. I'm a gun owner. I go to the range regularly. It's pressure for you to discharge
on the trigger. Yeah, and here's the thing: right. And when they did the demonstration, right? When they did the demonstration with a couple of the witnesses, I think the demonstration backfired because here's the question: how did he get his hand in the loop where the trigger is and pull it? Because he would have been, the gun was here. He would have had to push, not pull. It would push the trigger. Right. So, I mean, I'm just sitting there like, okay, y'all. I mean, common sense is how does he push the trigger forward? And then, of course, the video just destroyed all of that.
Yeah.
I think her explaining during the beginning how when her defense attorney was questioning her and she was talking about she goes to the range and she's trained and all this. So where did your training go all out the window? Because you talked about the training that you get on the range and what? So how would
that was made up testimony? That was absolutely made up. That was made up, Dennis. That shit was made up. And one of the things that I was upset was that the prosecution did not cross-examine her more fully when it came to the lies she made up about the training. Now, Clayton County, I'm not familiar with Clayton County, but I know that when you go to the range, you got to sign in, right? So there's going to be a record of every time you have been to the range. So why didn't the defense say you've been, the prosecution say, okay, what range did you go to? When? What was it? What's the name of it? Get my investigator, go call that range, and I want you to pull every record of every time she was there. That way we could see if she's telling the truth, and then you can impeach her on that. Then, second, they do classes at the range, but you have to go do a class. Otherwise, you're just going to shoot on your own. You know what I mean? And guess what? They don't teach you self-defense at a class. They teach you basic firearm safety, how to align your target, how to break your gun down, how to clean your gun, shit like that. How to ask so you know how to take your gun apart. Let me see you. Where's the takedown button? Right? Let's see. You really know your gun. Let's see where's the takedown button. You don't know because you're lying. Gerald, you're making up all this.
This is the part that I said maybe the judge is going to make his client pay. He showed up 30 minutes late. Everyone's waiting. Cameras are rolling. 3 cameras in the courtroom. 3 cameras in the courtroom. Court TV was able to get 3 cameras in the courtroom.
Right, but he said he had a prior engagement already. He told the court that. Everybody knew he had another case somewhere else in the courtroom that he was going to.
But this is a special set hearing. He's not off. You're not in Georgia. You're not off trial until the defendant is sentenced. So whatever the excuse he made up, he had another hearing or whatever. You could have been held in contempt. So I get that he was a little late, and this was not the first time that he hadn't, had an issue in court. And I'm not, trying to disparage the lawyer, but this wasn't the first time. So I kind of knew from the error in the courtroom, this was going to be a problem because, for Judge Scott to bring that out, Judge Scott is a very patient judge. She doesn't really, show anger or anything like that. But you could tell she was perturbed that people had been there for 30 minutes waiting for a special set sentencing. And so Hannah's really lucky that judge didn't take it out on her.
Right. And that the taking out would have been without parole.
Yeah.
Without parole.
Yeah.
She got everything else. Judge gave her everything else.
I mean, Judge for the most part threw the book at her and gave her an opportunity, 30 years from now to see fresh air. But given the current status of the parole board, she's not gonna see the outside of a Georgia penitentiary for at least 40 years.
Right.
So how much time does she have to do on the life sentence before the other 2 consecutive sentences kick in?
30.
So she has to do 30 years before she's eligible for parole. So once the 30 years is up, she's eligible, but then she does have to do the consecutive 5. So once she's eligible
and then she got
for parole,
right?
She got a consecutive 15, but the 5 is mandatory on the gun charge.
Okay.
So that's 35.
Well, consecutive. Okay. All right.
Yeah.
Well, she won't be going nowhere for a long, long time.
No.
And
that kind of segues back to a question I had about Jonathan Majors' case. So in New York, especially on a misdemeanor, do they not sentence the same day? Because on most misdemeanors in Georgia, you're getting sentenced that day. Now, felonies, because you are facing a substantial amount of time and you need to get your mitigation evidence. But on most misdemeanors, the judge is sentencing that day. And so my question, is it different in New York there or something because he wasn't sentenced the same day?
It is different here. You could be sentenced the same day if you waive your pre-sentence report and things of that nature. But because this is arranged, the judge is going to request a pre-sentence investigation report, which is going to tell him, things about Jonathan Majors, his life, and things of that nature, so that he can fashion a sentence that is appropriate under the circumstances.
Yeah.
So, that's why we don't sentence on the same day.
The price has
lesser
already
crimes they do. So.
Okay. Well, that's good to hear because most misdemeanors in Georgia, we don't do a pre-sentence investigation. You just have to have your mitigation ready if you unfortunately lose the trial to hopefully keep your client out of the county jail.
Oh, yeah. No, they got time. He got time. I mean, sometimes, depending on what type of case it is, even if it's a misdemeanor, like it's a sex crime misdemeanor, the judge will put the defendant in. Right? So he's lucky that the judge didn't put him in. If the judge is poised to give him jail, he could have put him in today.
Mm-hmm.
Right.
He could have.
He could have.
So,
but I don't think this was that type of case.
Not especially with the knowing the extent of the actual verdict.
What do we know about this judge? I like always getting inside baseball. What is this judge typically like?
What judge are we talking about?
The Jonathan Majors case.
Who was the judge? I don't even remember. Gaffey was the name?
Gaffey, yeah.
I don't
You ever been in front of
judge. I don't think I know that judge.
Well, he's a.
I don't think.
So he's a misdemeanor judge. Well, is it like do these misdemeanor judges do felony cases as well?
So he's a criminal court judge. So that would he's criminal court, which is the lower court.
Right.
Okay. It's the lower court here in New York. Right.
So it's sort of like state court in Georgia. You have state and you have superior.
Oh, okay.
Okay. So it's criminal and supreme here.
So he's not. Jonathan's not Supreme Court. No.
He's in criminal court.
Okay.
He's in
Okay.
criminal state court. It's state court, but it's criminal court. It's not the Supreme Court. That's the difference.
So
It's the
in New
same
York,
difference between state and superior.
so in New York, what is the name of the highest appellate court? Then is it not the Supreme Court of the state of New York?
No.
What is
It's
it
a
called?
misnomer here. The highest court here is the Court of Appeals, the New York Court of Appeals.
Wow.
That's the highest court. Technically, our lower trial court is the Supreme Court.
Wow.
It's a misnomer. I know my students hate it when I tell. They're like, wait, but yeah, well, don't be
Yeah, that can
married
get
on the
confusing.
word supreme because it doesn't always, mean that it's the Supreme Court. It's not.
It looks good when these court say, I work in the Supreme Court. You work. Okay. Yeah.
Well, the court system in New York is a labyrinth, and there's so many lower courts under the Supreme Court. So I think that's part of why we have that criminal court versus the Supreme Court, and we've, so many other lower courts under there.
Under the Supreme Court.
Supreme Court. Then we have the Intermediate Appellate Division. We have 4 of those covering all of the state.
Those are
And then
departments, right?
Is the Court of Appeals. Huh?
The different departments.
Right.
No, I
we
think
have
it's
4
different.
departments.
Oh, it's not. So it's
4
not
departments.
districts. So it's departments.
No. Departments. Yes.
Okay.
Our appellate courts are in departments. We have 4 departments.
Why?
Right? So
I knew that. You think I
the
knew
first department appellate court. Very good, Dennis. Do you know what the first department covers?
that? Don't do that to me. Don't do it. Let me ride with the departments. I don't know the rest.
The first department covers the Bronx and Manhattan. The second department covers Queens, Brooklyn, Staten Island. The third department and the fourth department cover the upper counties like Oswego and Orange County and all of those. The first and second department have appellate divisions. We also have appellate terms. The third and fourth departments do not have appellate terms. Their trial courts serve a dual function as the interim appellate court. I know it's a lot. Why are you asking me this stuff? This is stuff that students in law school learn.
Yeah, that's confusing.
It
sounds like
I was back in class.
Because it's further broken down even further because say misdemeanor cases, if you're appealing a misdemeanor, that doesn't go to the department division, it goes to the department term, right? So Jonathan Majors, when he appeals, he is going to appeal to the appellate term because he has a misdemeanor case. If it was a felony, he would appeal to the appellate division.
Oh, man. Okay.
All right, so that's where he's going to go, to the appellate term. If he loses in the appellate term, then he can go to the appellate division. And if he loses in the division, then he goes to the Court of Appeals.
Okay.
How long can he draw this out before a sentence?
I'm sure he got a date for sentencing today. When he comes back, he's going to be sentenced. Now, he'll be sentenced. What should happen after that is that his lawyer should make an application for bail pending appeal, right? Now, this is based on your likelihood of success on appeal. So she's got to be able to identify some places where she believes she will be successful and convince a court that she has the likelihood to succeed in order for them to give him bail pending appeal.
Oh, wow. Okay. So it's different. So in Georgia, you can apply, but it's not based on the success on the merits of the appeal. It's just you're going to actually appeal, and then you meet the the bail criteria under the Ayala factors, which we won't go into that. Yeah. But wow. So you actually have to have a cognizable appellate argument to get bail. So it's a possibility that Mr. Majors could be remanded, and serve the sentence. Wow. Okay.
Absolutely. The thinking of the court here is you have to demonstrate to us, right, that locking you up would be so egregious because if you win your appeal, we could never give you your time back. Right? We can't give you time back. And so if you can demonstrate to us that you might actually win, then we don't think you should be in jail while we decide this. So if you can't demonstrate to us that you actually will win, then why would we let you out?
He's not even on
That's
a
the
bond right
reasoning.
now. He's on his own recognizance. He's not even on a bond right now.
Yeah, right now until he returns for sentencing, and then his posture will be changed at that point because now he will be convicted and sentenced.
Mm.
That's a change of circumstances, right? Often you hear about change of circumstances in the court. That's what it takes for them to change your bail conditions, right? So if there's a change in circumstances, you went from being not guilty to guilty. Well, that's a change of circumstances that we're gonna revisit your bail conditions. So we'll see what happens on sentencing. Because I'm sure she didn't think she was gonna lose, so she's probably not prepared, right, for the post-trial activities.
Right. But that means she didn't manage her expectations.
Right. Well, listen.
You always have to manage your expectations anytime you walk
gotta
into a
manage
courtroom.
them. You really do. You really do.
Well, ladies and gentlemen, I do appreciate you, my panel guests, being a part of this live. It's a very important live, and each one of you brought a unique element to this conversation, and I really would look forward to having everyone back again on our next case, because we don't cover some serious cases, like, oh my God, some serious national cases. And I'm on two big cases right now, the Trump case in Georgia as well as the YSL case, and I have cameras in the courtroom on both cases, so I definitely want to be back and make sure that I have my great panel here, and let's discuss these cases. There's another case, by the way, that starts, I believe, tomorrow, and that's the YFN Lucci, and the attorneys on that case is Drew Finling and Gabe Banks. So I hope to have at least one of them on the as one of the panel guests at some point.
Oh, I didn't know they were starting.
Yeah, I thought Judge Cox said that would start the first of the year. So are they starting like jury selection?
Yeah,
and
they're still doing prelim, but they're
okay.
Yeah. So it's definitely going down. And they only have 3 defendants. I don't know if you guys are aware. It dwindled down to 3 defendants, and YFN Lucci was offered 17 years as a plea deal. So basically, that's an FU plea. You take this or take it to trial. So, that's going to be an interesting one. And we know
another trial for your radar.
Say it again.
There's another one. There's one in Kentucky. There's another trial for your radar. There's one in Kentucky. Right, I did a long crime this morning. It's called Kentucky versus Bryce. It is a triple homicide. This guy is charged with. Yes, Rambo was his name or something like that. Yes, he was an aspiring rapper who thought he was going to do a murder for hire. Like he found out, or he thought he knew there was a bounty on somebody's head. So he arranged for there to be a drive-by shooting, or he did a drive-by shooting, killed this person, happened to be the wrong person, so he didn't get paid. But the 2 young people who were with him, 14 and 16-year-old brothers, about a week or so after that, he killed them. Well, he had them killed, stabbed by other 17-year-olds to shut them up because they witnessed him do the drive-by. He then set their bodies on fire.
Yeah, I'm going to watch this one. Okay. Thank you for putting
It's
that on my radar.
Yeah.
Yes. Let's follow that one.
So then we have the one in Florida with the other rapper that is a retrial. The retrial of the rapper, I want to say his name.
Wyan Melly.
Wyan Melly.
Oh yeah, that's they retrying that. Oh my god.
Yeah, that's what I'm saying. They still retrying that.
Yeah, they're going to retrial that one. So we got a hands full, ladies and gentlemen.
How to work.
Make sure you like, share, you're following this page, and make sure you follow each one of my guests' page. And each one of them bring a unique style to the conversation. And I appreciate all of you joining me today. Any final words?
Thank you for having us, Dennis.
Yeah, thank you.
Thank you for opening the platform, brother.
Thank you.
And let me just say this really quickly for all of the people that are watching. There are 3 attorneys on here. You all have to understand that in our country, there are only 5% of attorneys that look like us. Only 5%, and we got 3 of them on here right now. That's big.
Heavy hitter.
That's
Heavy
big.
hitter.
I'm honored and I'm privileged.
Hey, ladies and gentlemen, I appreciate you. I really do. And now we're going to end this. We're going to end this, and we're going to be looking forward to the follow-up, even with this Jonathan Majors, and seeing how, they convinced the judge to keep him out of jail. But that said, ladies and gentlemen, thank you very much, and I appreciate you. I really do. I'm out.